Welcome to the Plant Grow REIT podcast.
Welcome back to Plant Grow REIT podcast. I'm Lee McColl, one of the lawyers here at Aintree Group Legal, and I'll be your host for this episode. Today I'm joined by my colleague and associate lawyer, Josephine Ziino, and we've invited along a very special guest, Sam Hopper, SC, Barrister extraordinaire. Thank you both for joining me.
Oh,
Sam,
thank you for having me. It's a pleasure to be here.
Sam, today we're going to be talking about you mainly and the work that you do as a barrister in your particular area, which is leasing and commercial property. So I wanted to give just a brief overview of the podcast. We're going to talk obviously about your life and your history, motivation, plans for world domination, starting off very small with the Victorian Bar. And we're going to move on to some interesting and topical matters that you've appeared in as a lawyer and as a barrister, and go over some very hot leasing topics. And then we can follow off with some tips for some landlords and tenants out there as well, and what advice, or sans legal advice, you can give them. So if we could, Sam, could we quickly start off with you and your history? Tell us about your humble beginnings.
All right, let's get started. I'll start by prefacing there is nothing humble about me or my beginnings. Now, I started law school at Monash University, mostly by accident, because all I wanted to do after I finished school was study history and philosophy, and I was convinced I was either going to become an actor or an academic, or a combination of the two. Overloaded on my arts degree, did honours in philosophy, mostly about a Star Trek episode. Then moved on to the inevitable at that point. I found I actually had to study some law. Worked with one of the academics out at Monash while I was studying law as a research assistant, with a view to starting an academic career out there, looking particularly at mental state defences to criminal prosecutions. I had dreams, Liam, of becoming a criminal lawyer. I was going to change the world of mental state defences to criminal prosecutions, and write the paper that changed everything. Anyway, I got swept up in the world of applying for articles at a big firm, as happens to all students at the end of their degrees. Ended up at Minter Ellison, did articles there, plus a couple of years afterwards. And Minter's was a great firm, but was the wrong fit for me. And after a couple of years there, I signed up for the Bar Readers course. And in fact, it's a funny story, I got a terrible performance review at the end of my second year there, articles plus 1 year, and was pretty clear that I was bombing out at the firm. So I ran off to the Victorian Bar the next day, signed up for the Bar Readers course, promptly made amends with the firm, and was back on track within a couple of days at the firm. Was no longer bombing out there and was doing quite well, but by that stage, both financially and emotionally, I was committed to life at the bar. Still had dreams of becoming an academic and criminal lawyer at that point. And despite Minter's being a commercial firm, most of my work there, the biggest file I worked on was the defence of an OH&S type prosecution after a fatality in a mine. Poor kid, aged about 19, was trying to jumpstart a mining truck and inadvertently overrode the park brake failsafe system, and the truck rolled onto the wall of the mine, and he was caught between the truck and the mine. And the poor bloke died. So we were involved in initially defending some charges, and then we pleaded out of those, and then had a coroner's inquest for a couple of weeks up at the Bendigo Magistrates Court, or in fact the Bendigo Court, which is a beautiful courtroom up there. And then I ended up coming to the bar to read with the barrister that we were briefing in that case, with a view to being an OH&S practitioner like him. And that sort of got me started at the bar, but it won't surprise you to learn that I ended up somewhere quite different to where I originally set out, what I originally aimed for.
Yeah, well, that gets us to our next point. So, I mean, you're the leasing man. You're the guy. So where's that specialisation?
Yeah, well, the funny thing was, I was when I was working for an academic out at Monash, was Bernadette McSherry was in it, still is. I was a little bit short of work over summer because the academic, staff sort of largely shut down over January. And it sounds terribly nepotistic, but my father played tennis with Mark Brennan, who turned out to be Victoria's, in fact, the Common Law's first small business commissioner under the Retail Leases Act and related legislation. But he was working at the time as a consultant to the state government doing a review of the Retail Tenancies Reform Act 1998 for the then, I can't remember if it was the Bracks or the Brumby government at that stage, whoever it was that took over from the Kennett government. And I was out at Monash University in the research room there, so I did some work for him at Monash Law Library, and that work was research that contributed to the review of the 1998 Act that ultimately led to the 2003 Act. So that by the time I got to Minter Ellison, I had this one line on my CV about retail leasing. And Max Cameron at Minter Ellison, who's their retail leasing transaction solicitor, I think he's just recently retired, sort of picked up on that on my CV, and I was suddenly involved in retail leasing work there, initially as a sideline to what I really wanted to do, which was this criminal prosecution in the commercial disputes area. Then when I came to the bar, my clerk, Michael Green, said, do your OH&S, that's a great idea, but just keep the leasing going on the side. He says, you never know. It's a good little fallback. And after about 4 years in practice as a barrister, I was doing a reasonable amount of leasing and a lot of OH&S. And I had a sliding doors moment where I was sitting in chambers looking at some grainy CCTV footage of an industrial accident where this poor fellow had been working down in the docklands and was working a hydraulic lift with a big H-beam on top of the two hydraulics. And one of the hydraulics was not connected. And as the lift went up, a D-shackle in the middle of the H-beam slid down, knocked the beam off the hydraulic, and the beam fell on top of him. And without going into too many of the gruesome details, I was trying to work out what the stain on the concrete was that I could just see in the background. Yes. And I thought to myself, I don't like this. There are people in the world that do this stuff. They defend prosecutions, and some of them defend prosecutions that are far, far worse than the sort of stuff that I was doing. And what they do is essential and noble, and we all need them to do it, but I can't. And around that time, I got a phone call from a solicitor who said, look, all of these agribusiness managed investment schemes have started collapsing. It's about 2008, I think. And they're all built on a leasehold structure, and the rumour is you know a little bit about leasing. So can you take on some work on these cases? And I said, okay, that'll be fine. What's involved? He says, what's involved will be pretty much returning every brief you've got and doing nothing else for the next 4 years. I said, okay, that's that. I'm a leasing lawyer now. And that was when I sort of started to focus on leasing law, and that's what I've been doing ever since. Right. And frankly, I love it. It's a fantastic area of law to work in, particularly when you're in retail, because you've got such a broad range of clients. You've got one day I'll be working for somebody who runs a fish and chip shop in the suburbs. The next day I'll be working for the controllers of a major shopping centre, and I'll work for everybody in between. So you get a great range of people, a great range of cases, and a great range of solicitors who are also for everything from the Dennis Denudo in the suburbs through to big law firms on Collins Street and everyone in between. It's fantastic.
Right. Well, this kind of leads us to where we are now and the famous Sam Barrister or samhopper.com.
Samhopperbarrister.com.
Wow, it's a combination. I think Josephine was talking to me about it before, how much it's helped her.
Yes, I was going to say, as a junior lawyer starting and working on leasing matters, your website was the go-to. Well, for me especially, or if I needed just something, just to an idea, especially after the cold storage case what the difference between a retail lease and a commercial lease is, I would always go to your website just for some guidance. So that's been always helpful for me.
And how many times did it go wrong for you when you followed what was on my blog?
Never. Never.
No, the blog's been fun. So when I came to the bar, I came to the bar in 2004, and the bar has, or at least at that stage, had a long tradition of not marketing directly to solicitors or clients. And that changed in the 90s and early noughties, but there was we at that stage as an organisation were pretty behind the eight ball when it came to marketing. And by 2010 or 11, I heard about blogs and how they worked, and I was pretty late to the party when it came to blogs compared to the rest of the world, but reasonably early when it came to the bar. And that's been a really fun way to market myself and promote my practice as a barrister. My clerk, Michael Green at the time, told me how blogs work, and it helped me set it up. And his words to me were that the best way to market yourself, the best way to get yourself out there is to give things away. Give away your intellectual property. Don't hold your ideas in. Let them go. Tell everybody about them. And maybe someone might use your ideas and steal them at somewhere along the way. But most of the time you'll get back tenfold what you've given away to the rest of the world. And he was completely right. You give a little bit away and you get a hell of a lot back. And the legal community are really good at recognising that and returning the favour. When I give away ideas and information and up-to-date knowledge, they return the favour by giving me the brief, whether it's 1 week, 1 year or 10 years later. It's been a great source of work for me and a great source of fun.
Yes, well, it's definitely helped us.
Yeah.
And it's good, especially with keeping up to date with cases. So it's, very, very helpful.
And I should say for anyone who's listening, the blog is not a device. It's not a substitute for a textbook. You should always have something like commercial leases, commercial tenancy law, or retail leasing Victoria, or any one of the leasing textbooks there to give you the complete picture on a particular topic. What the blog does is it picks out a case and gives you a snippet and tells you what that means for practice. But it's not a substitute for a comprehensive textbook. It's really it's a bit like an even more up-to-date loose leaf than a loose leaf.
Yeah,
but it's only the updates in the loose leaf. It's not the loose leaf itself.
It gives a very good snapshot. That's what I find, and it's very helpful.
Well, thank you.
So what's beyond the work that goes into the blog? What's life like as a barrister? Because when I started out as a first-year lawyer, I was working with Richard Cook, who sadly passed away in 2020, and he said to me, if I'm lucky, like all barristers, you get about 5 hours sleep a night. So what's it like for you?
No, I think I've got a great work-life balance. This is one of the things I like about retail leasing as a space. So when I started at the bar, like everybody else, I sort of opened the doors as a generalist. And I found as life progressed, the mod bar really rewards specialisation, I think. There is a place for the generalist, and we need generalists. But for me personally, and I think for a lot of barristers, specialisation allows you to be completely up to date on your area of law, and it allows you to be, if anything, ahead of the curve on that when it comes to an opponent who's a generalist. And also, if you take it back to this, the old 4 rules of advocacy that I was taught very early on were know your facts, know your law, know your judge, and empty your bladder. Right? Now, when you're a specialist in a narrow area, the first thing is know your facts. Most of the fact situations you're dealing with are not identical, but they have similar themes. So it's much easier to get on top of your facts when you're a specialist, particularly in, say, the leasing space, where a lot of the leases in the marketplace are the LIV standard lease. So I'm familiar with that document. And Minter Ellison's leases are everywhere. I know that one very well because I used to work on them when I was an article clerk. So getting on top of your facts is much easier when you're a specialist. know your judge. Well, I know all the VCAT members and I know the judges who sit on appeal. So I've got a really good, from retail leasing disputes, so I've got a real sense of the people involved in the decision making. So know your facts, know your law, know your judge. And of course, that means you don't get as nervous, so you don't have to empty your bladder quite so many times. So I find specialisation gives you a much better life balance, work-life balance. Personally, I very rarely work weekends and into the evenings. I can keep a good balance on work and keep most of it within the usual working hours, which allows me to be a dad and allows me to have my own hobbies and a life beyond the law.
Oh, cool. And so, what are those hobbies?
Oh, you know the main one.
Just reading.
It's fairly infamous at the bar. Would you like to tell the viewers what my main hobby is?
It's got to be the blog, right?
No, I've been involved in martial arts since I was about 9 years old.
Really?
That's interesting.
I had boxing and a couple of cage fights along the way. I've got a few different belts along the way that I've collected. So,
Really?
and as far as I know, I'm the only practicing barrister who's been in the cage. So,
Wow.
yeah.
Probably a good way to settle disputes in the future, maybe.
Look, I'd prefer to think of it as the alternative form of alternative dispute resolution.
So I guess that leads us somehow into our next one. What was your first matter that you really sort of cut your teeth on?
My first matter had nothing to do with what I'd done before or what I've done since. My first case ever was for a fellow called Mr. Singh. Can't remember his first name now. But Mr. Singh was a taxi driver long before Uber came along. Back when, and of course, taxi drivers need to have a taxi driver's permit, a ticket. And poor old Mr. Singh had a very, very, very drunk patron who not only was very drunk in the front seat, but was just racially abusive the whole way home, just saying all sorts of awful things about the poor fellow. And then she was, when it came time to pay, she was too drunk to put her own PIN into the ATM machine, the FPOS machine. So she swiped the card, told him her PIN, so he could punch it in, and then proceeded to start abusing him again and calling him all sorts of horrible names. Fell out of the taxi, legs akimbo on the nature strip, and then crawled away with the door open as Mr. Singh, fortunately she didn't vomit in the car or anything like that. Poor old Mr. Singh reaches across the car and has to pull the door shut from across the car and realises it said ATM cards on the floor. And in a moment of weakness, he decided to drive around the corner, check her balance and withdraw $200 from her account. He got done for obtaining financial advantage by deception, and I think he got a good behaviour bond from the court and $200 in the poor box. But when he came to me, he had had his ticket as a driver cancelled for 2 years. Because, of course, he's in a position of trust and it's an honesty offence against a passenger. And so my job was to seek a merits review of the decision to cancel his ticket in the magistrate's court. And so we prepped up the case and ran it. I actually had cause to look the other day at my old fee book, and I charged an embarrassingly low amount of money for the privilege of running this fellow's case. And I'm sorry to say, and I apologise again to Mr. Singh, that I reduced his prohibition, successfully reduced his prohibition on driving from 2 years to 2 years. So it wasn't a successful day in court, but we gave it a red hot go. We tried, but unfortunately we didn't get far for the poor fellow. It was a sad day for him. I kind of felt for the guy because, yeah, he did the wrong thing, but you can understand why he might have been tempted.
Yeah.
These things happen.
Yeah.
So, I mean, that's obviously not really your first big win, but what was your first big win that you remember?
Well, big win or big case?
Can do both.
So the first big case that I was involved with was actually when I still had a foot in two camps in terms of practice areas. I got a phone call out of the blue from a solicitor I'd done a bankruptcy case for randomly one day. he just said, "Oh, can you? What are you doing for the next year?" And I said, "What do you mean?" And he said, "Oh, kind of got this case that's blowing up, and we need a third junior on it, or something like that." I said, "Okay, what's it involve?" And he said it was for the Palace nightclub in St Kilda. Now, looking around the room, I think everyone here is probably too young to remember the Palace nightclub. But you know the Palais Theatre in St Kilda?
Oh, yeah.
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 There's there's a big empty block next to it that looks like it's got some foundations. That just to the right of it, not the Luna Park side when you're facing the front, but the other side. It's now a car park, I think. And there used to be this enormous, terribly ugly building, like a prime example of sort of 70s brutalist architecture, that was the Palace nightclub. And it was a sort of nightclub that I remember trying to sneak in there with my brother's ID when I was at high school. It was one of those sort of iconic clubs in the venues in the 90s. And the tenant who was in occupation under a Crown lease was in the unenviable position of having their lease about to end. And our job was to try and keep him in for as long as possible and extend the lease for as long as possible. And so by the time I got into it, there were 2 silks and 2... I was a second junior. I think I said third junior before I was a second. It had Clyde Croft, Tim North, the late Peter Nugent, and then me. And we're running this case, and it just, every time we did anything, it got bigger and bigger and bigger. And it got to the point at one stage where we found a memorandum signed and sealed by the Governor and Council from 1970 promising another 40 years of tenure or something to that effect on fulfilment of certain conditions precedent. And in order to, that promise was made to a deregistered company called Palais de Danse Proprietary Limited. And so my client got in contact, looked up Palais de Danse Proprietary Limited, realised it had been deregistered for about 40 years, found out who the shareholders were of the deregistered company, bought a future interest in the shares of the deregistered company that would crystallise into a real interest once registration was reinstated, and had entered that agreement, went to court to reinstate the registration of that company, was unsuccessful at first instance, so had to appeal that to Justice Gillard to reinstate the registration of the company, was successful on appeal, then went back and ran a case in the name of the reinstated company, while at the same time fighting to keep the state out of the property in the name of the actual tenant company and its subtenant. So we were running, I think there was, at one stage, I think there were 4 pieces of litigation perhaps running. And it is still, at least to the best of my knowledge, the litigation that has produced the largest number of judgments in the retail tenancies list at VCAT in the history of the tribunal. So,
Right.
yeah. It was good fun.
How long did that litigation go for?
All up, it went for about 2 years, I think. And it was absolutely manic. It was fantastic fun.
Right.
What did you do to celebrate at the end?
So as it happened, for reasons I won't, I might discuss with you offline.
Okay.
I ended up out of the brief by the trial at the end, and ultimately the reason it wasn't my first big win is that ultimately my client lost, and then about 6 or 8 weeks after they vacated, the Palace nightclub burned to the ground.
Oh, gee, okay.
No one was ever charged.
Right.
Yeah.
Wow. I guess that kind of leads us into some hot topics that we want to go, because we've got you here and we wanted to sort of go over some sort of big things that are going on in the leasing world. And I think our first one that Josephine and I are unfortunately all too familiar with is rental caps.
Indeed. Well, that's our case, isn't it?
That's our case, yeah.
Rental caps are a bit an interesting question in retail leasing. So the Retail Leases Act, as Liam, I know you know, regulates the bases on which rent for a retail premises lease can be reviewed. And rent under a retail premises lease can only be reviewed by a fixed percentage, some kind of index like CPI, a market rent review, or there's a fourth one. What's the fourth one, Len?
That's a great question.
Fixed, CPIs, market rent review.
Was it a fixed amount?
Or a fixed amount. You're right, it's a fixed amount. Well done, I'm glad you're here. And Section 35, subsection 2 says it can be reviewed by one of those methods. And there's also a subsection that says that you can't have a ratchet clause, a clause that prevents the rent going down below a particular amount. As of about 2023, there were a run of cases at VCAT. And funnily enough, they'd never come up before, but from 2023, there was about 2, 3, maybe 4 in a row, where the tribunal held that either CPI with a cap or a market rent review with a cap was a mixed form of rent review that was not one of the prescribed methodologies, and so was inconsistent with the Act and was void. And then the outcome is that the rent for that lease has to be reviewed to the market, or the current market rent by a valuer. And there were, of those 3 or 4 cases, one of them was a case between Northcote Shopping Centre and its tenant Aldi. And Northcote was successful at first instance, but then appealed that decision to the Supreme Court, and Justice Croft in the Supreme Court heard that case and handed down a decision just before Christmas last year. And he's overturned the position held by VCAT and held that, in fact, caps are permissible under the Retail Leases Act for fairly complicated reasons, but the upshot of it is that, in His Honour's view, the mischief to which Section 35 was specifically directed was landlords who were putting ratchet clauses in leases and preventing rents from going down. And if the mischief was that Parliament was directing its mind to was preventing rent going down, there should be no reason why a tenant shouldn't be able to enter an agreement to prevent rent going up beyond a particular amount. So that was, not entirely unexpected as a result, but certainly different to what all of the decisions at VCAT had been. So we are now, on behalf of Northcote Shopping Centre, appealing that to the Court of Appeal, and we're in the process of preparing that appeal for a hearing in the Court of Appeal at some stage, hopefully towards the end of this year. Will be a fairly short hearing, so hopefully it won't go into next year, but we're still waiting on a date from the Court of Appeal.
Yeah, right.
And that's an interesting one because there's a lot of retail tenants in the marketplace that I'm hearing about that have got caps like this. Aldi are quite well known for having them across the board throughout the state, and apparently there are quite a number of other tenants that have these sort of caps in their leases. And so I think Aldi's increases are CPI capped at 6% and market capped at 10%. And there are various other iterations, variations on that theme throughout the marketplace.
Yeah, no, interesting. I say that I sort of can't wait, but I'm one of the people who are also in conjunction preparing that appeal with you to see the outcome. So I guess whatever happens.
We're both waiting with bated breath.
Bated breath, yeah. And when there is an update, we have a judgment, I'm sure we can have a Sam Hopper Part 2 where we can talk all about it.
Well, I would, of course, recommend that all people watching this blog keep an eye on samhopperbarrister.com for regular updates on the appeal of the Northcote Aldi decision.
That's right.
So that will probably lead us into our next topic, which is duty to maintain and repair.
Yes.
So this is one that's sort of kind of fond to me because when I was started out at my previous firm, I worked pretty heavily on a matter which was the Brotherhood of St Lawrence and Serena Investments, which went to the Court of Appeal, which was mainly about the a landlord's obligation for duty to repair and maintain, which also involved a bit of questions about repudiation.
That's the most interesting question in that case.
Yes. And it sort of took over my life for quite a while. I think it was all that I dreamt about unfortunately. But for those who don't know, did you want to discuss what, that under the Retail Lease Act, even though that was subject to a commercial lease, what the duty to maintain and repair is?
Yeah, that's a really interesting case because, just by way of background, for quite a few years now, we've been sort of knocking on the door of this question of whether a landlord who fails to properly repair or maintain a property could be held to have repudiated the lease, allowing the tenant to accept that repudiation, terminate the lease and vacate the property. And it came up in a case called Versus. I can't remember the rest of the parties. VRSUS was a case that was originally heard by I think it was Senior Member Riegler as he was then. It was then appealed up to Justice Croft, then went back to Senior Member Riegler. That kind of came very close to a finding that the landlord had repudiated by not repairing and maintaining the property properly. But it didn't quite get there. Ultimately, there was no finding of repudiation by the landlord. And there have been a number of other cases that have sort of hinted at it and nudged it. And there was one sort of finding that was landlord's repudiation, but on a slightly different basis. And the Brotherhood of St Lawrence case is the first case I know of from a superior court in Victoria that's held that a landlord has repudiated a lease by failing to adequately repair and maintain. Now, Liam, you probably know a bit more across the facts in that case than I am. But as I understand it, you had Brotherhood of St Lawrence occupying either the second or third story in a building, second. And it was not a retail lease.
No, commercial.
And there was a balcony of some description on the property. And some tiles had fallen off either the floor or the wall of the balcony that had come from movement between concrete slabs that were used to construct the building. And the tenant got a report, and it might have been a report from a tiler, although I'll be correct if that's wrong.
Was an engineer.
An engineer who expressed concerns about the structure of the building. That report went to the landlord. The landlord was very slow to respond to it. And again, I think the landlord's response was to get another report from the same fellow who repeated his concerns about the structural integrity of the building, and then didn't take any steps to investigate further or repair if necessary. Tenant was understandably quite concerned about health and safety of their staff, who I've never seen the building, but as it was described in the court's judgment, if it came down, the staff would have been pancaked in between, squished like a pancake in between. So they, after an exchange of correspondence with the landlord, ultimately said that the landlord had repudiated the lease by failing to repair and maintain, and they vacated the property, and then and moved to another property. And I think it was the landlord that then sued the tenant for damages.
Yeah, that's correct. That's right.
The tenant then defended and counterclaimed, saying, "No, you're the one, Mr. Landlord, who breached the contract, and you need to pay us damages." Now, Judge McNamara in the county court heard it at first instance, and he took the traditional view the view that's traditional in these landlord and tenant cases, which is that other than a denial of the lease, refusal of access to the property or something along those lines, it's very difficult to find that a landlord has repudiated the lease and awarded some damages in the landlord's favour. That was then appealed to the Court of Appeal, and that was where the really interesting finding took place as far as the future, the development of leasing law is concerned. As the Court of Appeal held that the landlord's failure to further investigate and take steps to remedy the problems in the property was a repudiation that allowed the tenant to accept that repudiation and terminate the contract, and was awarded damages for it. Now that's, just as an aside, interestingly, the landlord tendered reports at trial to say that in fact the damage was not very significant. But the problem with that is that was all too late in the eyes of the Court of Appeal.
It was some years later.
Yeah, and the repudiatory conduct in the face of that was not taking further steps to investigate and confirm that the property was safe and didn't require further work. And so that's so that becomes a really interesting decision from a landlord-tenant point of view, because traditionally, before this decision, your remedies as a tenant when you've got a landlord failing to repair and maintain, even seriously like this, was to either sue for specific performance of the landlord's repair and maintenance obligations, although there's some old cases saying you can't even do that, but I think you probably can in a modern court, or do the work yourself and sue for damages, being the cost of the work and economic loss for the business interruption caused by doing the work. This then opens up a whole new remedy, which is if it's bad enough, you can shut the doors and walk. Now, that has a couple of effects. Firstly, it means that I should add also, that doesn't mean that you can run away the moment there's a crack in the wall. Right? It's got to be a serious breach, and it's got to be a breach that amounts to a repudiation by the landlord. There's all sorts of contract law about what constitutes a repudiation, albeit in different contexts. But basically, it has to be a very bad breach by the landlord. But firstly, it gives the tenants in that situation a remedy that allows them to walk away and sue for damages rather than continue to trade in a defective property. But secondly, it also gives you, even if your argument is not going to win at trial, it gives you an arguable remedy that the landlord's repudiated the lease, which can give you all sorts of leverage and negotiating power, bargaining power in a post-tenancy environment.
Yes, I guess that's a good segue into the next topic we've got here, where the tenants got rental arrears and then the tenant's ability to make a counterclaim for damages to offset those arrears. And we've got the AMTB Proprietary Limited and Chan case.
Yeah, that was a case that was just handed down a few weeks ago, but it's at the injunction stage only, so it's not trial. But one of the things that came up both in that case and in the Paramount Investments case, which we'll talk about next, was that the tenant was in arrears of rent. And in the AMTB case, what happened is the tenant was on the ground first, second floor, right, or third story. The retail premises lease, and they're running a bar and nightclub on the second floor. And beside, there was a staircase that would get you up to the second floor, and there was a lift as well. And the lift was constantly playing up, and it was sort of just getting worse and worse over time. And the tenant had taken the step that a lot of tenants do, which is they started withholding rent to sort of pressure the landlord to complete repairs on the lift. It had probably withheld, it was maybe 4 months, maybe 5 months worth of rent. And then the landlord sought to terminate the lease. In fact, less when the landlord terminated. It was only about 3 months when the landlord sought to terminate. I think they served their default notice on about the 21st of December or something like that. And the tenant wanted to use a damages claim caused by the failure to repair the lift as a defence and offsetting claim against the rent arrears. Now, for round numbers, let's say they were, I can't remember the exact numbers, but let's say it was 150 grand in rent arrears. Though the tenant said that the problems with the lift had caused many times that in economic loss to them, call it, let's say it's $500,000 worth of damages. And they said because the damages claim directly caused the problems to the business, which caused and contributed to the rent being withheld, that gives rise to an equitable set-off, not just a counterclaim, but a counterclaim that goes to the root of and impeaches the rent claim itself and acts as a defence to the rent claim, and gives rise to an equitable set-off. Now, that's quite a common argument in these sort of cases, except that it runs up against a hurdle, and that is in the lease is a covenant that says the rent is payable without deduction or set off whatsoever. And there's a line of cases that say that normally a no deductions or no set off clause defeats an equitable set off. Now, and there, in fact, had been a line of recent cases at VCAT in the last, and the Supreme Court in the last sort of 2 or 3 years that have upheld those sort of covenants. And what we argued in the AMTB case was that based on a decision from Judge McNamara when he was sitting as a Deputy President of VCAT back in about 2010 or 11, there was a case called Sine Delavares that held that if the covenant that you say the landlord has breached to give rise to the damages claim is a statutory covenant you cannot contract out of, then you cannot contract out of the equitable set-off, and the anti-set-off clause doesn't apply to a breach of that covenant. Now, the way the argument works is this. You say, I've got Section 52 of the Retail Leases Act that requires me to maintain the premises in a particular condition. Let's say it requires you to maintain a working lift. Section 52 of the Retail Leases Act it imposes that covenant, implies that covenant into the lease. And Section 94 of the Retail Leases Act means you can't contract out of Section 52. Now, if you can't contract out of Section 52 or the covenant implied by it, then it must be the case that you also cannot contract out of the remedies associated with a breach of that covenant. So to use an absurd example, imagine you had Section 52 in your lease, and a reference in your lease to say, yep, Section 52, the parties recognise that Section 52 is implied into this lease by operation of the Retail Leases Act, but the tenant can't sue for damages for breach, full stop. Well, that's clearly not going to be enforceable, because to say you can't sue for damages for breach of the covenants implied by the statute is in substance to contract out of the covenant. Make sense?
Yeah.
Similarly, you might have a silly example that says the parties acknowledge the covenant implied by Section 52 of the Retail Leases Act, but the tenant can't sue for specific performance of that covenant. Well, that'd be contracting out of the covenant as well, because it's cutting off one arm of the enforcement of the covenant. Well, if you accept that proposition that you can't contract out of the remedies associated with the breach of Section 52, so the argument goes, it must follow that you can't contract out of an equitable set-off that flows from a breach of Section 52. And Deputy President Riegler at VGAT accepted that argument, at least at the interlocutory level, and we got an injunction for the tenant, and we're now gearing up, I think, for mediation, and if we don't succeed at mediation, then we're off to trial.
Right. I can see that being a growing area of litigation, which sort of brings us to another growing area of litigation, which are these challenges to rent reviews.
Oh yeah,
as well. So have you seen some growing areas in there? With this
rent reviews are interesting. As you know, what we're talking about here is market rent reviews. It's pretty standard in leases in Victoria to have a market rent review every 5 years or so, usually on the exercise of an option, but sometimes a mid-term as well. And a rent review is pretty heavily, a market rent review under a retail premises lease is pretty heavily regulated by Section 37 of the Retail Leases Act, and to a lesser extent Section 35. And traditionally, outside the VCAT context, the retail leasing context, setting aside rental determinations has been very, very difficult. There was a case called Legal in General in about 1988, which set out the general principles. It was a decision of Justice McHugh and others when he was sitting in the Court of Appeal in New South Wales. And that sort of set out the basic law that made it quite difficult for someone to challenge an expert determination like a rent review. In VCAT in the last few years, there's been a lot of, despite that, there's been a lot of rental determinations that have been set aside. And one of the main reasons for it is that in about 2014, there was a decision from VCAT that was appealed to Justice Croft in the Supreme Court that talks about a provision of Section 37 that's unique to Section 37 and rarely found in commercial leases, which is a requirement in the lease not just to provide reasons or sufficient reasons for the rental determination, but to provide detailed reasons for a rental determination. And detailed reasons requires the valuer to set out an extraordinary amount of detail in their rental determinations. And what we've found in the 10 or 11 years since that decision back in 2014 is that a lot of VCAT has found that a lot of determinations just aren't reaching that threshold of detailed reasons. And a few of them are going for other reasons as well. But I think in the last 11 years, we've probably done, I think the last count was something like 22 determinations that have been set aside for failing to provide adequate or detailed reasons. So we're finding a lot of rental determinations are being set aside. And now, in the current market, particularly in a post-COVID world, as particularly inner city rents have been pretty erratic, there's a lot of people who have been seeking to set aside rental determinations either because they've gone down too much in the eyes of the landlord or not gone down enough in the eyes of the tenant. And there's been quite a bit of work in that space, setting aside determinations.
What examples of detailed information?
So one of the ones that causes a lot of determinations to go is that a lot of valuers will refer to a series of comparable properties that they have regard to, and then they'll mention that they had regard to other transactions, the details of which are held on my files, full stop.
Oh, right, okay.
That one's very common. I reckon there's been about 6 that have gone for that reason. There's another one where there's a bit of a disconnect between Section 52 on the one of the Retail Leases Act on the one hand and perceptions of repair and maintenance obligations in the marketplace generally. Now, Section 52 of the Retail Leases Act says that a landlord is responsible for maintaining in a condition consistent with the condition of the property when the lease was entered into various bits, basically most of the property other than the tenant's fit out. So most of the repair and maintenance obligations placed on the landlord. Most leases, including the LIV standard lease, say that the tenant is responsible for pretty much everything other than structural repairs. And the perception in the marketplace, including in the hands of most valuers, is that the tenants are responsible for everything other than structural repairs. So what we see in a lot of determinations is a valuer who'll say the Retail Leases Act applies to this lease, and then they set out what they call the lease epitome, which is where they summarise the terms of the lease, and they summarise in that epitome the covenant of the lease that requires the tenant to repair and maintain. Now, in some cases, particularly in old pubs, repair and maintenance bills can be huge. And then built into that, there's another layer as well, which is that in most pub leases, tenants are required to paint every 5 years. And at least on one view, which is controversial for other reasons, the landlord is required to do that under Section 52, although there's a debate about that. But the valuers conduct determinations on the basis that the tenant's required to do a whole lot of things on their side of the balance sheet, which drives down the rent because it's a tenant repair. But if Section 52 applies, and particularly if it applies with one construction relating to paint, that means the landlord has to do those things, which drives up the landlord's costs, drives down the tenant's costs, which drives up the rent. So that's a problem we've seen in probably at least 3 or 4 of them. And then there's sort of a series of other issues unique to each determination where the valuer has sort of taken a step in his or her reasoning that hasn't been fully explained.
Right. Following on from that, it's my favourite part, horror stories.
Horror story.
So when has a landlord or even a tenant done something that, it's just, even for you, it's like, I can't save this. This is horrible. Have you seen something that the other side have done or you've gone?
I did. Oh, I did have one who my client, when the brief came through, give me a hand signal if you think this is inappropriate, but I'll start telling the story. My client was a landlord of a property, and he actually had an office next door to the property, and the property had was running a massage place, and he was one of their most regular patrons, and he used to use the services of one particular young lady for his massages in a particular room that was the one that was shared a wall with his office. He ended up one night just getting a builder to come in and punch a hole in the wall and build a door directly into that room so that he didn't have to go via reception. Most of the ladies who tried to massage this fellow would leave the room crying and it wouldn't have anything to do with him. And then ultimately the young lady who was massaging him either left or refused to have anything to do with him anymore, at which point he went into the room via the door he'd knocked into it, boarded up the door so that the tenant couldn't access that room, and installed a kimchi chef into the room that they had that was part of their leased property. Now, I don't know if you've ever been into a kimchi kitchen, but they stink. And so this kimchi chef was stinking out the rest of the massage facility because he was so angry at having been excluded from their services. And ultimately, there was nothing I could do to help that fellow. It was, it was not an ideal landlord. I think so I couldn't help him. One of the other horror stories I had was I got a phone call once from my clerk who said, I've got a solicitor on the line who's looking for a barrister who knows a little bit about property law and a lot about how to handle himself in a fist fight. And I said, Greenie, that's not the best sales pitch I've ever heard for a brief. And he goes, you don't have to accept it, but that's the invitation. So I spoke to the guy who was running it, and he said, look, we've got a self-represented litigant on the other side who has different views of appropriate forms of alternative dispute resolution to perhaps you and I. I said, what does that mean? He says, he came to the front desk of our office a couple of days ago, and shirt fronted the woman on the front desk and started threatening her about us evicting him from the property. And as a result, we've got to be careful as to who we brief. But what we did notice is that when some burly blokes came out, the guy backed down immediately. So we figure if you're over 6 foot, you might be a bit more meek and mild towards you. I said, okay, we'll give it a go. So we rang the tribunal and gave them the warning. They could put the warning dot in the file. I get to court. I'll get to VCAT, the tribunal, and we've got a member there who's an older gentleman. He's not a mobile guy. He's pretty stiff and sore, and I think he's got some pretty bad sciatica. Known him for a while. We're sitting there at the desk, and my opponent's being very civilised beside me. It was a good day. In fact, he was to my right, I remember. So we were facing the member like this. He was on that side. And the day went well. We got our order. He was well behaved throughout the case. And then we got to the end of the day, and he says, the member said, all right, we got judgment for us. I said, okay. He says, is there anything else for the parties? And he stood up and he goes, yes. He goes, I know the law and you got the law wrong. He starts pointing to me while staring at the member, and he goes, and I've got a gun and I know where his office is and I'm coming to get him. At which point the member, who was generally, as I said, an older gentleman who didn't move very well, was out like a shot. I've never seen him move so fast. And I thought, the only person in the room who's got a panic button, and he's just done a runner straight away. So I'm sitting there on the rollers, the coasters in this chair. The fellow's next to me like this. I start rolling my chair around the edge of the table like this. And eventually I get to the outside of the other side of the table. And I realise as I turn around the table why it is that the member felt comfortable running out as quickly as possible. As I saw a glint of blue in the corner, and two of Her Majesty's finest were at the front door holding an intervention order.
Oh, wow.
The young lady from the front desk who'd been shirt-fronted by the tenant 2 days before had used the intervening period to go and get an ex parte intervention order and sent 2 police down to VCAT to serve him. Wow. And they were sitting there in the background watching this fellow threaten a member of council on the transcript in front of a VCAT member with 2 cops recording it in the background.
Oh, that's awesome.
So anyway, we had we ended up getting them to come. I spoke to the coppers afterwards, and they said, look, the fellow probably doesn't know the difference between a barrister and a solicitor, so he probably doesn't know where your office is. But just in case, we want to come up and speak to the people on your floor. And I said, look, we've got a receptionist on the front desk on our floor, so it would be a good idea to talk to her. So they came up to my chambers, and they sort of spoke to everyone on the floor, but particularly the woman on the front desk, and they said, this is a vague description of the fellow, and they showed him, I think they might have had a photo or something like that. And they said, basically, if anyone of that description comes in, gets out of the lift, because the lift's would open right in front of her desk, you are to run to the nearest room and lock the door behind you. And so on at least 3 occasions, people who looked vaguely like this guy arrived on the floor, and she's just gone, run to the door, slammed it, and locked the door.
Poor thing.
So what a welcome for a client in those circumstances.
Yeah, jeez.
Do you know what ended up happening?
Oh, we never saw him again. He was
Okay.
evicted from the property, and the threats were all a bunch of hot air, fortunately.
Yeah.
Yeah, sometimes it's majority of the case, isn't it? It's just hot air.
Yeah, that's right.
But always got to tread carefully. In light of that, with what we've discussed, what are some tips that you'd like to leave for landlords, tenants?
I mean, I suppose it comes out of what we're speaking about. It's a general point. And that is, there's 2 very different styles of lawyering required for landlords on the one hand and tenants on the other when you're in this space. I mean, we've talked a lot about re-entry and termination of leases today. And in the re-entry and termination space, there's 2 very different styles of lawyering. When it comes to a landlord's lawyering in that space, you've got to be very thorough, and you've got to be very diligent and very conservative in your lawyering. You've got to make sure that there is no substitute for a well-drafted lease that has that gives your landlord client the best protections it can have at the beginning, and well-crafted default notices that are well-written, well-prepared, well-served, and the re-entry is well-timed. So a thorough, dot every I, cross every T lawyer is what a landlord needs in this space. Tenants, by contrast, when you're looking at the re-entry space, tenants need a creative lawyer who can think outside the square and think about ways in which to overcome anti-set-off clauses, ways in which to avoid rent determinations or challenge rental determinations that might bring your rent into a different space, that can tinker with a re-entry and stop it being effective. And really that rewards a creative lawyer rather than as much as it does the thorough and the diligent lawyer. That's the main sort of takeaway I'd give from our discussion today.
Yeah, great.
Sure. Was there anything else you wanted to
No,
ask? Was there
I'm
anything?
richer for the experience.
Yeah, same here. It's been an interesting.
Well, thank you for having me. I hope it can inspire some more people out there to become landlord and tenant lawyers. It's actually a lot of fun.
Well, a huge thank you to you, Sam Hopper, for joining us on the podcast today. We really appreciate you sharing your experiences, insights and expertise. For me, it's really interesting to know that you had like a generalist background before going practicing in the leasing space. But thanks for tuning into this episode of Plant, Grow, Reap. Please subscribe wherever you get your podcasts, and we'll talk again soon.
Thank you for having me.
Thank you.
Thank you.